All right, people, we're live. We are live, and it's been a while. Actually, if I'm looking at my live streams, the last one we did was 5 days ago. How's everybody doing? We're gonna let people trickle in. Robert is not yet in the house, but he's reliable. I told him I would do a little intro and build it up. Oh man. Let's get started just with saying hello to everybody who is already here. I would just like to bring up some random names. Randomly, I don't mean like that. I would like to bring up names randomly, I should say. We'll start with Wyatt Rosebrook, because I know I've never seen that name before. Mika Creepy Joe interview was great. Thank you very much. And as people trickle in, we shall say hi to everybody. Why is Blue 923 taken? I've seen you before, Blue. Barnes & Noble is a tool for the globalists, not related to, you should have said not related to Barnes the Noble, because I consider Barnes to be noble and phenomenal. Jacob Wall says, I hope Uncivil Law skips this live stream. Okay, I don't know what's going on there. He tweeted me actually right before and said, should we go live tonight? And hadn't yet gotten the notification for this, which was a last minute notification. Let's see what we got here. Dirk, the avatar that I've never understood, but I like the avatar. I've been hoping you do a live stream with Robert Barnes concerning the Flynn FBI matter. So here's the deal. I sort of know what I don't know, and I can recognize where I think I may not know things. Flynn FBI, I have my own impression. It's a very superficial understanding. I want Robert, if he can, to elucidate me and the rest of us as to why it is not more offensive than I think it is, which is pretty offensive. So we're gonna get there. And I got questions about the Michigan stay-at-home court ruling, the other states' rulings on similar issues, and the general impact questions. So we'll see where this goes. Becky Ryan, this should be interesting. It most certainly will. Becky, nice to see you. I don't recognize the avatar or the name, and it's good to see new faces. I'm going to slow down a little bit. Okay. By the way, check that out. How good is that product placement right there? Boom. Vlog. The kids and my wife are watching Biggest Little Farm or Little Biggest Farm. Biggest Little Farm, I think. It's utterly captivating, by the way. We started watching an episode last night at 11 o'clock and went until 12:30. And utterly captivating. Yvette G, can't wait. Yvette, nice to see you. Nice to meet you. Lucy Ann, looking forward to this. VF and Barnes. It's going to be fantastic. And I'm going to give, because I noticed there's a super chat, and I'm going to give advanced warning. Oh, Uncivil Law is in the house. I love it so much, but I missed a few. The women negotiated. The women were offered what the men had negotiated. They said no. This decision, by the way, for anybody who's watching now, the U.S. soccer team, Nate Brody, another YouTube lawyer, not the other because there's more than two. Nate Brody called me up. I think it was like Nate was in the zone and called me up at 8:15. He texted me first, then called me. And we talked for about an hour this morning, about 8:15 to 9:15 about this decision. It's an amazing decision. Oh, I missed things already. Oh, no, I didn't. It's an amazing decision. The decision, when you read it, is going to blow your mind as to what you thought you understood based on media coverage. It's going to blow your mind. And not in a gender-based, like men versus women, male versus female, men's soccer versus women's soccer. It's going to blow your mind because you're going to realize the nonsense that you were being fed by the news was nonsense. Factually, legally nonsense. This is not the subject matter for this live stream, but it will be for another one. Greg Utz, I know I've never seen you before because I would remember your name and that avatar. Thank you. Viva Roberts, cheers, friends. Thank you very much. I reserve the right during this live stream to miss super chats because I want to have. It's going to be time constrained a little bit, and theme specific. So I may miss super chats. I'm going to apologize in advance, but I reserve the right now. In fact, I don't need to reserve the right. I've always had the right. Good thing you didn't get that gun, Viva. So, funny story. Like we had talked about this in previous chats. I don't want to turn this one into that either because that's another stream that's coming and vlog. Trudeau, through order in council decree banning certain firearms, while Parliament is not sitting because of the Maya Sharona Cyrus, and that's it. It's just, no public debate, no nothing, but whatever. And spoiler alert, the intro to that vlog when it's coming is, no matter how much you might agree with a law, that is not how laws are intended to be passed in a free and democratic society. So yeah, it's interesting. We got Professor Chaos. I know you, I remember your name, but you've changed your avatar. You really need to read License to Lie by Sidney Powell, Flynn's current attorney. Andrew Wiseman has a history with the Mueller of corrupt prosecutions. It needs to be on audiobook, because other than that, I'm going to be, I fall asleep when I read books. There is no such thing as random. It is an illusion. Melvin Hawkins. We got Anonymity. I know I've seen your avatar before. That's a very cool avatar. Not going to read it, but yeah, so that last video is kind of taken off. It's kind of interesting. Let's see what we got here. We got Derek Masio says, on the fact that the guy who had yeah, the first casualty of war is truth, and yeah, it's crazy. It's actually crazy. We got, as a Michigander, I'm very excited for the stream. I'm just gonna message out to Robert, make sure everything's good. Oh, about to hop on. Perfect, comma. I'm keeping them busy. Smiley face. So I never knew it was actually Michigander, which is totally cool. I said Michigonian. Michigonian actually sounds better. And there's like, there's Michigana, which is like, some expressions for it's very Michigonian. I like better. Michigite, Michigander. But I like it. What's good for the Michigan is good for the Michigander. I'm just going to shut my big mouth now, aren't I? We got Licardo Guira says, how can a fellow attorney volunteer for Barnes Legal Group? Okay, I'm going to post Barnes. If anybody can do it for me now, I'm going to get Barnes to remind us what his website is, because he has a website and there's ways to do it because he's looking for it. So when he gets in, I'm going to ask him to remind us what it is. If anybody knows, post the link, and I will post it in the pinned comment when this chat turns into when this stream turns into a video. What do we got? And by the way, thank you very much, everybody, for the super chats. Thanks for the content. Hello from Iowa, Mr. Squirrel. Wait a minute, Mr. Squirrel. Are you the channel that has a squirrel that gives good advice to kids? If you are, remind me, because you just brought back a memory that I had of an email that I got, which I don't always get back to the emails, but certain things trigger memories. If that is you, Mr. Squirrel, thank you very much. One way or the other. Things are moving fast. Things are moving fast. We got Mr. Squirrel. Robert is not yet in the house, so we can do this for a little while longer. Mark Hargis says, Viva Fry, much love, bro. If you can ask Robert if in a civil case came up in Louisiana, can an out-of-state lawyer come argue it with us holding a Napoleonic code? Can't wait to see you in New Orleans. Screenshot. I believe that would be called... there's a Latin word that we had in the vlogs where you go and ask for permission to plead on a specific issue in a state. I suspect, I'm not even certified anywhere in the United States, but there might be a way to be recognized, and not an amicus curious, like not a friend of the court. If anybody can remind me of what that word is, let me know. Dude, it would be great for content from a cynical point of view. It would be even better for justice. And oddly enough, that which is good for justice gets people's eyes, because people are starting to, I don't want to say wake up. People are becoming sensitized to the risks of how discreetly a police state can sneak up on you. I see Robert's face in there now, so I'm gonna say hello to the new member, T Craft 5604. Nice to see you. We're gonna get Real Bambunga in the house. Believe, Tier or Read. Oh, I see what he's doing here. Okay. I want to make sure I got everything. Okay. We got that. This is going to be good. We're going to start. I don't know what we're going to start with, because I want to do the topics, semi-coherently, but we're going to do both of these topics. Professor Chaos says, too long, don't read. Reisman loves to make up charges that don't actually fit the statutes he claims and then hide Brady material. We're going to find out what's going on. We're going to start with the FBI. We're starting with the FBI. That's it. What's good for Michigoose is good for the Michigander. And a new member, Christina Gonzalez. Christina, nice to see you. Okay, now might be the time where I'm going to enter the realm of not necessarily being able to get to the super chats. And before I get to that realm, I'm going to address the last two that I saw. Off subject, not allowed. another mug, but sit on the chubby side. Could there be a bigger sizes to the wearable merch? When the My Sharona Cyrus is over, I'll figure out the merch situation. Right now, I'm just, focusing. I'll figure it out. I'll see what I can do. But thank you very much, TCraft5604. Who are the new member? You get the little icon. That's beautiful. And we got Abel Sell. Abe Sell says, can you be my daddy? No more kids. No more kids. My wife said no more kids. Okay. No, it wasn't written mandamus is what I mean. I'll get Robert in. Robert's going to come in. Robert is in the house. Do you have to be arrested or fined to sue over these draconian shutdown orders? Interesting question. Let's bring in Robert and let's start the discussion. Robert.
Hey.
How you doing?
Yeah, good. A little bit crazy day, but otherwise okay.
And you're all well? Everything's good where you are?
Yeah, just crazy. But yes, in Tennessee currently, back to Texas tomorrow, so it's been eventful.
What are you doing in Tennessee now?
I was interviewing some various media networks are doing some documentary type stories, and so they wanted to do an interview with me this weekend here. And so that's why I was here today. Plus, had to meet up with some other people related to both legal matters and business matters and family matters. So all of it combined. Because my daughter lives here. Almost all of my siblings live here. And so, it's catching up with everybody at the same time.
Okay, amazing. And everything is good. No, there's nothing. I shouldn't even ask you that because if there is bad stuff, we might.
Yeah, all's good.
Okay, amazing.
Aside from the craziness of the world we're living in.
Someone says, love the potato can from the hotel room.
Yeah, exactly.
What is most important in Robert Barnes is his voice and his knowledge, and you don't even need a camera for that.
Right, yeah.
Okay, so I'm going to try to keep this as focused as my hyperactive OCD brain can get. We want to talk about the Flynn FBI to elucidate to those who may not appreciate why this is so egregious. And then we're going to get into the Michigan judgment, which I think we can all appreciate why it's so egregious. If we're starting from the beginning, let's start. You're familiar enough with Michael Flynn to educate us?
Oh, yes.
Okay, so explain the context. What was he? How did he get pulled into this? What was he charged with, and what was he convicted of?
So Flynn was targeted originally. There's the government story. The government story was that they were looking into whether or not he violated the Logan Act, about whether or not he was representing the United States in an unauthorized way prior to his appointment as national security advisor. And that was the original pretext, that they went and interviewed him about matters related to it, that according to the government, he had lied to them. And that led to him being removed for his national security advisor because Sally Yates and other governmental officials went to Vice President Pence and then ultimately President Trump and said that accused General Flynn of lying to them and lying to the FBI. That led to the investigation. The investigation went broader than that. It looked at everything he had done in the last 30 years, basically. But ultimately, he originally pled guilty to one count of making a false statement to the FBI in that original interview about the subject of the Logan Act questions, which were whether he correctly recalled the conversation he'd had with the ambassador to Russia in that interview with the FBI agents.
Okay, and actually, the first interruption, the Logan Act is representing the United States in foreign affairs without authorization, give or take?
Yes, the Logan Act has never been used. It's back from 1799. It's never been used in the history of the United States to prosecute anyone ever. So that gives you an idea of how, as soon as I saw them referencing the Logan Act, my view was that this was simply absurd. That this was politically motivated, that it was likely pretextual and so forth, just because the Logan Act is never used. That's part one. Part two is the Logan Act actually does not preclude someone who is part of the transition team from having conversations with foreign leaders during the transition, which General Flynn was recognized as part of the national security team. So in that context, there was simply no legal base. There was nothing wrong with his conversation with the Russian ambassador. There was nothing illegal about it, even if the Logan Act was something that one could seriously look at, and it historically had never been that. And so between those two, that was reason to second guess what was happening here. But that's what the Logan Act is. The Logan Act is mostly It was originally on the books, a lot like the emoluments clause, which has also been misappropriated legally in the last couple of years. It was on the books because the concern was that a young government would have people go overseas, pretend to represent that young government, but not in fact have the authority to represent that young government. There's constitutional speech problems with the statute as applied. That's why the statute's never been applied, just like the emoluments clause has never been applied. The emoluments clause similarly was concerned with someone who was going to become an assistant diplomat, and once they became an assistant diplomat, they would use that power they would go over and they would be corrupted by, say, the Tsar of Russia or the Duke of France or the King of France. And he would say, "Hey, I'll give you a dukeship in exchange for if you see some black light going in and out, because there's a storm here in Tennessee." So everything that could go interesting has gone interesting of late. But putting that aside, it's truly not. Don't worry, anybody. It's not the CIA coming in. It's not someone coming to the side door. You might reasonably could be concerned with that these days, but I'm okay. But that's the nature of what's taken place. So they used the Logan Act as the excuse to get him. The argument against Flynn by the press and by the people who prosecuted him and punished or tried to punish him was, hey, look, he pled guilty to lying to an FBI agent. And Chris Wallace's argument on Fox News was, hey, that's a crime, period. Nobody should worry about the FBI using some quote unquote tough tactics. That's the institutional narrative on General Flynn. In my view, the more accurate narrative is that this was a case of entrapment. They went after him knowing he had no motivation to lie. He knew they had a transcription of the conversation they claimed he lied about. So why would he lie about that? He had no motivation to lie, no interest in lying, no incentive to lie. So this was a classic entrapment case where you get someone to do something they would not have otherwise done but for your inducement, which is to get them to fail to recall the exact nature of a conversation. You don't think it's consequential. You don't know it's a criminal case. You think these are buddies and pals of yours that are going to be working with you in the counterintelligence, counterespionage world. They don't tell you they're there to interview you for a criminal case. They don't even give you any warning. They don't even advise you it's a criminal case, despite Lisa Page advising them to try to sneak that in. And then their own FBI agents come back, write up notes that say, we don't think he lied to us, or even if he made inaccurate statements, we don't think he intended to make any inaccurate statement. Then they bury and hide those notes. They create doctored fake notes called 302s that are they're supposed to be the typed up version of the written notes. Instead, it's someone else typing up fake version of what took place in the written notes.
So and if we go back to do we know the nature of the lie for which he was convicted or the lie to which he admitted? Like what was the nature of that lie?
He didn't recall the precise scope of his conversation with the Russian ambassador and whether he had discussed certain subject matters in that conversation.
So his lie is, he says, I don't recall the scope. I don't remember what I said. I categorically did not discuss this when he categorically did type thing.
It was more like, hey, did you discuss this issue? But you didn't discuss this issue, right? And he was like, yeah, I think that's right. I did discuss this and I didn't discuss that. So he's assuming they're telling him the accurate rendition of the conversation because they actually have the tape and the transcript. So that's how that conversation happens.
Okay.
But later on, when he's looking at it, he's like, maybe I just screwed up and got it wrong. So, they gaslit him into believing, I must have just got it wrong that day. And, okay, it's a false statement and they're going to come after my family. They're going to come after my son who just had a kid. They're going to attack everybody. I'll just plead and go home and forget, not go bankrupt continuing to fight this when he was already on the way to bankruptcy by fighting it that far.
So they get him on this inaccurate statement, press charges for lying. What is it? Not lying to Congress? Is it lying to the FBI?
Lying to the FBI, making a false statement to the FBI.
Okay. And he pleads guilty. What does he get sentenced to?
So his sentencing was scheduled to happen, and that's when all of this took a different course. So he shows up at sentencing. The judge hears the issues, and Judge Sullivan is well known. He's very idiosyncratic. Doesn't mean he's going to be a good criminal defense judge. It just means he's very idiosyncratic. Many years ago, Judge Sullivan presided over the case of Senator Ted Stevens from Alaska, who was prosecuted there in the District of Columbia on corruption and bribery charges. He convicted Stevens. He sentenced Stevens. He was going to whack Stevens further. And all of a sudden, an FBI agent who was a whistleblower came forward and said, by the way, Judge, we actually fabricated and withheld a lot of key evidence. That so upset Judge Sullivan that he has instituted routine, broad orders on issues related to discovery. So when Flynn originally pleads, a different judge accepts the plea, a judge who's involved in the FISA warrants cases. Somewhere along the way, that judge realizes he has a conflict of interest and recuses himself. That case then gets assigned to Judge Sullivan. So when it's sentencing time, it's in front of Judge Sullivan. And Judge Sullivan expresses concern about two things. One, he sees evidence in the record and statements from General Flynn that suggest General Flynn may not have committed this crime, or at least doesn't believe he did. He's also concerned that General Flynn believes that he's been promised pure probation and that that's what he's going to get if he goes forward with the plea. So what the judge tells, he gives him the carrot and the stick. He tells General Flynn, I'm not going to sentence someone who believes they're innocent. And by the way, if you go forward, I'm going to treat this as a treason case and give you a harsh sentence. General Flynn's like, that was a total shock from what his lawyers had been telling him, the Covington law firm out of the District of Columbia, where very politically connected firm. Eric Holder is a partner at that firm, to give you an example. To give one example. And so he realizes he's got problems. He says, Judge, I need to wait on sentencing to re-examine issues with counsel. Discovers that he's got issues with counsel, gets rid of that counsel, brings in Sidney Powell, who is a longstanding federal appellate counsel. And her perspective is, she wrote a book called License to Lie. And her perspective is that there's a lot of discovery abuse in the federal criminal process. I can tell you, without going into details about it, there was a point in time in which I may have become one of General Flynn's counsel. For a range of reasons, it was not a good fit. It wasn't good timing for me to get involved. But I did believe that his hiring Sidney Powell was a good idea and advised them of so. And I believe that if he went through a discovery research and review, he would find that, in fact, the government committed a lot of misconduct in this case, given my instinctual understanding and life experience in criminal defense and federal cases like this that are politically oriented or politically tainted. He does, and ultimately that leads to him demanding a bunch of discovery, and then he ultimately moves to withdraw his plea, and that motion is still pending before the court. And as part of his motions for discovery, the government and his former law firm suddenly discover they have a bunch of information that's helpful to his case that they've been withholding or had not produced before, including original notes and things like that.
Okay, so actually, I want to get there in a second. So Divinity says the judge asks for exculpatory evidence. Is that normal? It sounds like the judge was, I mean, maybe I'm projecting, hypothesizing, imagining. It sounds like the judge is twisting Flynn's arm, knowing that by threatening him with a more severe punishment than that for which he was prepared, he's going to get Flynn to retract his plea and expose this, or is that totally fabricated in my own head?
Nobody knows. So there was alternative interpretations of why Judge Sullivan did what he did. I can say as a general rule, ever since the Stevens case, Judge Sullivan has required broad, expansive discovery and made sure that prosecutors and agents complied with those discovery requests, even when they don't normally think that. They normally think in a plea case, they don't have to turn over any discovery. It's not really what the law is, but that's the norm. Judge Sullivan has said, I don't care what the norm is. You're going to turn over anything that could be helpful to the defense so that I don't get burned again like the Stevens case. So that's the background of why he did that.
Okay, so very interesting. And now, who turns over these notes? Where are these notes discovered? In the hands of Flynn's attorneys, or does the judge compel them from the prosecuting attorneys?
So what happened is the judge really hadn't compelled a lot of these yet. In fact, the judge had actually been, excuse me, the judge had actually been very skeptical and critical about prior efforts to get discovery. He was very critical of Sidney Powell even. So that led people to think, okay, maybe the judge is in serious individual new independent prosecutors to oversee all of these cases, Roger Stone and General Flynn, to review them for constitutional adequacy and accuracy in the discovery process. And it's after that point that it's the FBI and the Justice Department that produces these documents that had always been in the FBI's possession and custody that they just hadn't turned over. And somehow at the same time, the Covington law firm says, oh, we did a new search and we discovered all these other documents. My hunch is that the Covington firm was tipped off. The FBI was producing a bunch more stuff that might include documents that they had not turned over. And so they came up with this story, is my interpretation. maybe totally legitimate. We'll find out in time.
But
so that's the correlation. The law firm finds out the FBI is producing information, so they suddenly say, oh, you know what? We do have a lot more records than we produced. We did the algorithm search wrong the first time.
So this is what I don't understand now. So Flynn there have been depositions already. Flynn has been charged. He's pled guilty. What round of depositions, like what is the context of these depositions now that he's already pleaded guilty? This is for sentencing depositions?
So none of these are depositions technically. So what happened was when they did the interview, there's two different sets of notes that are relevant. One is the agent's set of notes when they did the original interview with Flynn. But the second separate one was their internal notes about their own internal meetings. And this is where Alex Jones has been critical of this, but where Scott Adams has had a lot of fun with this. So Scott Adams has been pointing out this has got to be the most comedic form of criminality in history, to sit there and take notes. Okay, I'm going to go over to General Flynn's house. Maybe I'll kick his dog or cat. Okay.
Yeah, I saw that. That was quite funny, actually.
Maybe I should burn these notes later? ?
And then there was a graphic of a male genitalia and General Flynn bent over.
Yeah, exactly. I mean, so that was the equivalent of what these notes were. Now, they might have been taken by someone who did not like the attacks on General Flynn, so he was creating inculpatory records to impeach his fellow agents whose policies, whose prosecutorial decision-making he disagreed with. But either way, what these notes showed was that they had discussions about, one, there was no legitimate open investigation. It turned out that people had done a review of his 30-year history before this and had recommended the case be closed, that the agents kept it open arbitrarily, that they invented the Logan Act after the fact, that what the notes say is, what is our goal? Truth, admission, or just to get him to lie so we can get him fired or prosecuted? Well, that's literally, it's like an internal entrapment note. How do I get this person to commit a crime they would not have otherwise committed? The only purpose I'm even talking to them is to induce them to commit something that I could call a crime. And it's worse than the Marion Barry case. I mean, one of the interesting things is the defense that Chris Wallace on Fox News was making was, hey, you know, he lied to the FBI, so it doesn't matter. Well, actually, it's never a defense on the government side to entrapment that the crime actually occurred. Entrapment, by definition, the crime actually occurred. So even if I have doubts, I don't believe he actually lied under oath. But even if you believe he did, if the government entrapped someone into lying when they had no otherwise motivation or incentive to lie, just like here, and it's never a defense to entrapment, like the Marion Barry case. They got him to use the crack cocaine by his mistress saying she's not going to sleep with him unless he does a hit of crack cocaine. They arrest him for the crack cocaine. It was all part of a setup by the FBI. Ultimately, that had to be thrown out because the question was, would he have done the crack cocaine but for the FBI creating the set of circumstances? The answer is no.
So two things. On the entrapment issue, entrapment is not a defense to the actual commission of the crime, but if the entrapment...
it is.
But if the entrapment reveals an ancillary crime, I presume then that nonetheless a conviction on the ancillary crime could be legitimate?
Entrapment is actually a defense to the crime. So you have it's considered an affirmative defense under United States criminal law. But if you can prove the government entrapped you, then that you're not guilty of the crime.
Okay, but that would be, hypothetically, that would be on the crime of lying. But let's just say, you wouldn't be found guilty on the crime of lying because you were entrapped. But if in the context of that investigation, they found tax evasion, the entrapment to the lying wouldn't be a defense to the actual tax evasion that they may have otherwise discovered.
Correct.
Okay, so when it comes to Flynn, first of all, I never even knew Marion Barry I never knew he was set up for the crack. I mean, I only knew the meme 20 years later, because we all know Marion Barry smoked crack, was the mayor that smoked crack. I never knew there was entrapment in there. But for Michael Flynn, he was only charged with lying as to his recollection of a specific conversation, and he pleaded guilty to that on the basis that he was not going to serve any time and get probation. He only gets in front of the sentencing judge, who was a substitute for whatever the reasons, and the sentencing judge says, I'm going to convict you for espionage based on what you did, unless you want to retract your plea, or not your plea, but sorry, your admission of whatever it is called. I guess it's a plea.
Yeah, in essence, what he tells him is, look, if you don't believe you're guilty, I'm not going to sentence you. But if you do believe you're guilty, then understand that I'm not bound by the plea agreement, and I see this crime as equivalent to treason. Now, the judge got some basic facts wrong in that comparison. He later sort of tried to walk that back after a media break. in the case, and just during the day. The context of it led Flynn, I think, reasonably to presume that if he was going to go forward, he was not going to get a probationary sentence. And at that point, that was his only real reason to do it. It wasn't the probation; it was to make sure his son didn't get prosecuted and his son didn't get punished. But part of that was that he was not going to do actual prison time, and he could do several years inside. And so, given that, it was like, well, that doesn't make sense. When he knew down deep, he never believed that he was ever guilty. He had been gaslit into believing that he must have made a misstatement at the time of the interview. But he'd been gaslit into believing that, because down deep he was like, I had no motive to lie to anyone. Why would I lie to people who have the transcript of the file?
The argument will be he didn't know they had the transcript when they were asking him the question.
He did. He did. In fact, it came up during the conversation that they both admitted that they had the transcript of the conversation. Okay, well, he's like, you guys already know.
That's mildly relevant. Wash Your Hands says, didn't Flynn do time? Where has Flynn been kept in the meantime? Has he been liberated, or has he been in jail?
He's been out on bail, so he's never done any time at all.
Okay. So that's amazing. So in the conversation, they're saying you have the transcript of the call, but let me just test your memory on it, ask you some questions. He gives an incorrect. I'm reluctant to use the word lie, even when it comes to adversarial examinations, but he gives an incorrect answer, which they then say this is a factually incorrect answer based on what we have of the transcript, which we knew that you had when we examined you. And then he says, okay, well, I plead guilty. I lied, probation, whatever, and I won't see a day in jail. Part of the plea bargain is you leave my kid alone. What would they have gone? What role does the kid have? Does his son have in all of this?
So there's two things about the plea involving his son. One is that that's not something you're supposed to do. The Department of Justice is supposed to do. So that's why they're not supposed to threaten prosecution against other people to get you to plea. Now, they do it frequently, but it's usually off the books. So they usually do it in such a way that it's not part of the formal plea agreement itself. That's what happened here. They also tried to deny it, and then there were internal emails and documents that proved what General Flynn was saying all the time. Because there was a period of time in which the people anti-Flynn were saying, oh, Flynn's just making this up. This had nothing to do with why he pled. Well, now the internal documents from his law firm, now the internal documents from the Justice Department prove, yes, they in fact were threatening his son with prosecution unless he pled. The issue with his son was both he and his son were put under intensive investigation, microscopic investigation for everything they'd done in their whole lives. And in that context, for several years after General Flynn left office when he worked for Obama, between 2014 until he was working with President Trump in 2016, during that 2-year time period before President Trump was elected, he had represented various governments in making arguments about public policy issues before the various public officials in the U.S. government. And that was the only time period he's ever done it in his life. The law firm that was working for him during that time frame was the same one that was supposed to be defending him in the criminal case, when it turned out they had a conflict of interest because they may not have properly handled all the paperwork, because both he and his son were part of that. The interesting thing about all of that is it's under the Foreign Agents Registration Act, FARA. There's only been 6 criminal prosecutions in American history under that law. And so it can be broadly and unconstitutionally interpreted. Nobody knows exactly what it means and how it applies. It's intended for a limited scope of circumstances, but they've applied it to a much broader. To give an example, General Flynn was not hired directly by any foreign government, but he disclosed that the source of the funds were connected to that foreign government, Turkey, anyway. So they knew what he was doing. He disclosed what he was doing. The only issue became, did he and his son get everything right on the paperwork? They couldn't find that he did anything wrong. So they said, you know what, we're going to look at your son and we're going to try to find something that your son did that we can say is a criminal law violation. And his law firm, unbeknownst to him, had a conflict of interest because they would be implicated in any mistakes related to it, already had been, gave him bad advice in that capacity. And the case that was ultimately prosecuted in Virginia was so bad, the judge ultimately dismissed the charges in the case, related to other people that were part of this, not Flynn and his son, but other people that were connected to Flynn and his son, related to lobbying on behalf of the Turkish government. And so it turned out like he was never a unregistered foreign agent. He was never a foreign agent, really. He was someone who represented political groups who had connections to a foreign government, who, if that's a crime, 80% of Washington can be put in prison tomorrow, because that's the nature of their currency, of their political power and economic influence, and economic self-enrichment is some way, shape, or form aiding a foreign government, usually the Middle East, sometimes or China or other countries, or Europe, as the case may be. So it was a highly unusual prosecution. But if you're Michael Flynn, you've never been through the criminal process before, your law firm is telling you you have no choice but to do a plea or your family may suffer badly. The government's saying, don't worry, if you do this, nobody's going to suffer any bad consequences ever again. The government's telling you and gaslighting you into believing something happened that didn't happen in the conversation, in terms of what you intended, hiding the notes that say their own agent said, hey, he didn't intentionally lie to us at all. And throughout that entire process, you're going through a process you've never experienced before. He's never been through the federal or state criminal process of any kind. It sounds scary. It sounds terrifying. Mueller's going after everybody, everyone, and everywhere, including anyone connected to General Flynn. I was contacted by people that simply had an affiliation or association with General Flynn that Mueller was trying to target and harass. And these were high-ranking, well-regarded military and law enforcement officials in our government. So they used Flynn to take out all of the potential allies, all the potential white hats that could have protected Trump. It was part of a political campaign, in my view. Now we have a lot of evidence to back that up. It was more interpretive when I originally suggested it, but now there's more evidence behind it. But that's basically what happened. It was an extraordinary case of government entrapment over the most exaggerated set of charges ever witnessed, using every coercive tactic known to man, benefiting from conflicted counsel in the process that they almost all got away with, but for one judge having to recuse himself and another judge having been burned before by government corruption.
Amazing. And now Rebecca Gallant says, I'm praying he sues the hell out of the government. Would this be one of the cases that's getting close to malicious prosecution or no?
It's almost impossible to sue a United States attorney. Almost impossible to sue the FBI. So even if they had no probable cause, and that they clearly in their own internal notes had no probable cause to instigate the investigation in the first instance, the law is so tough that it's very rare that you can bring a malicious prosecution case in the United States, even rarer that you can win them. My guess is that won't be his inclination. His inclination will be to seek public vindication and re-participate in the political process with that public vindication.
Okay, and I'm just going to read one joke from The Real Bambuga. It says, is anybody else having trouble believing the right honorable FBI of J. Edgar Hoover would ever do something dishonest? So, okay, I mean, if you have to, in a sentence, because what I said is like, this is sort of my understanding of what had happened. I'm shocked, I'm appalled. I sort of know enough to know why it's so shocking and appalling. If you summarize it, and I'm going to timestamp this for my excerpt from the highlight I'll post tomorrow. If you summarize it in one sentence, or let's say 2 paragraphs, why is this so shocking, and what is it about this that is so shocking that every God-fearing citizen, let alone American citizen, should be outraged by what they've witnessed or what they know of now?
If the highest ranks of the Federal Bureau of Investigation and the Department of Justice can do this to someone like General Flynn, imagine what they're doing to ordinary people and getting away with doing to ordinary people all around the country. That's the shocking and unsettling thing, because here was a guy who was supposed to have a sophisticated defense. Here was a guy who was one of the most well-regarded military officials in the country. Here's a guy with no record of any problems or questions or controversy in his entire military career. Here's a guy who is the #1 national security advisor to the newly elected president of the United States. If he could be taken out so effectively, so quickly, not only from political power, but from any degree of political public reputation or prominence, and then criminally prosecuted and railroaded into possible prison time, then you can imagine what they're doing to everyday people. And when the only thing he did wrong was trust FBI agents were being honest with him when they sat down to do a casual interview that they said was part of his job, not for an independent investigation. I'll be getting some people that will push back and say, oh, well, if the FBI knocked on my doors, I'd pay attention to what I said. But the FBI walked into General Flynn's office every day when he was a national security advisor, because they're working with him in the counterintelligence, counterespionage units of the Federal Bureau of Investigation and the Department of Justice. That's part of their job, is to coordinate to see who's doing what, who's saying what, so on and so forth. That's why he knew they had recorded them. That's why he talks about the fact they had recorded them. And so he's just thinking, hey, they're probably just asking for something rather than going back and reading the transcript. They want a quick version, and they already know what they remember, and they're just checking with me. And he's not thinking it's anything formal, anything full, anything the rest. So if they could set out to get someone like him, and these were people that were at the head of their departments, these were at the head of the most politically sensitive departments in the country, then you can imagine what, if some ordinary FBI agent in your local neighborhood decides he doesn't like you, imagine what he can do to you if what they did to Flynn is what happened to Flynn is what can happen to you. And that, I think, is the terrifying aspects of this case.
That's amazing. And so Andrew Starr says, Robert, move the light, brother, so we can see you. Robert, can you move 30? No, like go if you can rotate yourself 35 degrees to the left.
Like this?
No, like with your computer, just so we shift the angle of the light.
Oh, I have to also turn more light on.
That's already better. Okay, that's already better. So just so everybody understands, the FBI, there were internal notes for whatever the reason. Flynn's attorney had these notes, or they were disclosed by the FBI. But who disclosed the notes first, FBI or Defense Attorney's Counsel?
So two different sources of information. In terms of the FBI's notes, those were only turned over by the FBI recently. In terms of the law firms had other emails and of conversations they had with the Justice Department that they separately turned over. So the FBI had never turned over the key notes that got turned over last week.
And the only reason those notes got turned over, we discovered something, we somehow slipped through the cracks. Here they are. Was it with a 10,000-page document dump on a Friday afternoon, or was it like, here are 3 pages you might want to look at? Do we know?
Here's my guess as to what happened. The person that Attorney General Barr had to re-review the case decided all of this information was relevant, and he turned it over in one grouping. That he went through everything and said, okay, here's what I think is relevant and pertinent.
I want everybody who's not a lawyer to appreciate that. Is like when you're a lawyer and you ask for communication of documents, typically you'll get, if it's a small file, you get a few hundred pages to 1,000 pages. If it's a big file, you'll get a hard drive of documents that are like, classified by date, by format, whatever, and go through it. And to the extent that they've given it to you, their hands are clean. And so, presume whatever, who knows what happened, but you get 10,000 pages, and someone has to go through it meticulously and find handwritten notes, which are barely legible, saying, what's the goal of what we're doing with Flynn? To get him to lie, to get him fired, and to prosecute. And that's after everything. And had that come out in the beginning when it should have, under the principle of full disclosure and honesty from the FBI, it's mind-blowing. It's absolutely mind-blowing. It's crazy. I know, incidentally, I'm just going to bring this up because I've never seen 10,000 of any units in my life. I have. No words necessary. You're doing good work. Jason Minor, thank you very much for the super chat. It's definitely a foreign currency. That's crazy. So they just disclosed that it hits the fan and everybody picks up on the news. Some people, how about the defense for this was that his behavior is standard behavior. Oh, so that's exactly where I was going. So the media comes out and says, big deal. This is what the FBI does all the time. That's the MO for the FBI.
It shows two things. One is, to the degree that's true, that says something very disturbing about the FBI and the Department of Justice and our criminal justice process in the United States that suggests we need a full-scale purge of a lot of people in positions of power in those departments. To the extent that they're exaggerating or trying to mislead, then it shows the media bias in the case. I think it's a mixture of the two. There's definitely aspects to where the government can and does do this routinely across the country to political targets. It's not accurate to say they do it in most of their cases, not in my experience. The second aspect is that the reason why they're saying that is they're trying to pretend entrapment is normal. And this is sort of like the FISA abuse. I remember when originally their defense of the FISA applications and search warrants against Carter Page and everyone else connected to Carter Page that warrant allowed, because that's the nature of a FISA warrant, was, hey, this had to be based on really good evidence because they would never grant a FISA warrant unless it was compelling evidence. And I was like, I don't think so. I've seen some of these FISA warrants in other cases, and I've seen completely weak predicates for them. And then, of course, it turns out, in fact, there was no strong precedent for the FISA warrants. So then they come up with a different story, which is, hey, we get FISA warrants for crap all the time. And so it's totally normal. They totally reverse their excuse, but they suggest somehow that because it's customary, it's somehow morally or legally okay. And I don't understand that argument, because the fact that it is or could be customary is even more reason for the court system and for the Department of Justice and for us, the public, to see remedial action taken. The more this is commonplace rather than rare, the more we need intervention into the system, not the less we need. The less excusable their conduct is, not the more that it is. I mean, imagine if a criminal got pulled over and they had been caught, stealing $10,000 from somebody, and they said, "You can't arrest me for that. I've been stealing 10 grand from every person I meet for the last 5 years."
No, I would
call that a good offense.
No, I would think of even more offensive protocol violation would be, cops always turn off their body cams right before they pull out their guns. Like, if that would be the case, why didn't you have the body cam footage? Well, we turned off our camera right before. Well, that's shocking. Oh, well, we do it all the time. It's standard protocol. There would be an outrage. It is outrageous, because it's almost like, not systemic, but it's almost like tolerated corruption, where you're like, okay, well, that's how they do things. That's what we see in the movies. That's how they get the bad guys. And yet when they get the good, I don't know if Flynn is a good guy or a bad. How many years did Flynn serve in the military?
Over 30. So, I mean, with an impeccable record. I mean, that was the other fascinating thing that they had withheld, was they had actually done a full-scale review of his entire record and his entire life prior to all of this being launched. And the FBI agents came back and said, "You got to close this. There's literally not a single speck of dirt on this guy. That is purely an impeccable record." And then they still launched this. I mean, that just showed their commitment to and their corruption of the politically motivated parts of our law enforcement and government.
Okay, crazy. So Madam Moncook says, "My friend Judy Barry did prove the FBI bomb school instructor built and planted the bomb that detonated in her car in Berkeley, California. Environmental activist." Okay, Madam Moncook, not that I don't know anything of what you're saying right now, but thank you for the comment and thank you for the super chat. And interesting. I mean, not know anything about it. I know nothing about that. Full disclosure.
Nor do I. Yeah.
Okay.
I cannot speak. It sounds vaguely familiar, but I can't speak to it in any detail.
And I'm just going to go through these because it's a good time actually to now switch on to the second topic. We've covered the offensive part of this FBI thing, and now anybody who didn't know why they should be offended, now they know why. It'll be up to them to determine whether or not they are in fact offended by the MO. Ronan Shelley says, "My dad is a former FBI agent, and he is of the opinion that the issue is not the FBI in general, but the people in DC who became political. I don't think a typical agent would do this."
Definitely not within the FBI. What he's referring to is a common view of a lot of FBI agents is that this is what they call a seventh floor problem. The seventh floor of the J. Edgar Hoover building in Washington, D.C., being where all the key political appointees are located. He's definitely right that everything that went wrong here was done at the seventh floor. Your line level FBI agent did not participate in this, did not promote this, did not support this. Routinely, when they had any power, tried to shut it down. So there's good arguments on that. I would say in terms of the FBI writ large, about 75, 80% straightforward agents. I've dealt with some that are not on the seventh floor, but are rogue. But they're about 1 in 5. They're not the norm in the FBI. IRS, different story. Half the people in the IRS, they're nuts. They belong in a nut house. That's my view of the IRS. I have a very less than pleasant view of the criminal investigative special agents in the IRS.
Okay, we're going to say, could Flynn's lawyers be held accountable for conflict?
Yes, because they may have committed legal malpractice. Now, it's tough to sue a criminal defense lawyer in legal malpractice because usually you have to prove you're innocent, but here Flynn may be able to do so. And so that gives him an opportunity. Also, Covington's a very politically conflicted firm. Probably wouldn't like some of their other information coming out, especially once they hired Eric Holder as a key partner. So I think there's even more political embarrassment that could be headed their direction. It would not surprise me to see the Covington firm write a check and pay General Flynn back for all the fees that he paid them at a minimum related to the mishandling of this case once he's vindicated.
Okay, very interesting. Now I saw 3 more. Viva, let's see this here. How'd that happen? Viva, did you become a lawyer because your dad was a lawyer? Was your dad like Howard Stern's dad in Private Parts meant? No, I did not become a lawyer because of my dad. I became a lawyer notwithstanding my dad, and my dad was never like Howard Stern's dad in Private Parts because he never called me a moron. Shut up, you're a moron. Senior government off invest should be vetted by AG first. So, by the way, thank you very much, Joel Boyley. Senior government officials investigations. Yeah, I mean, okay. So actually, one more thing before I forget. Judy Barry sued and won several million, but she died before she saw the money, unfortunately. Okay, thank you for the clarification there, actually. And okay, one more here. Someone brought up a good point. How many people didn't want to serve in this administration out of fear of this type of thing? And furthermore, what is the damage to the future? That's that. To quote the phrase from the last video, that's a feature of this system, not a bug. I think my personal impression, being a Canadian watching this from outside, is intimidate the living bejesus out of anybody who would think of serving Trump. So you deter anybody with common sense from this type of scrutiny.
And in particular, Flynn knew where all the white hats were in the national security establishment. So if you attribute what happened here to, say, a deep state, in terms of a dual state of people within the national security apparatus who are hostile to Trump, the greatest threat to the deep state actors, or the shadow government, or however people want to characterize it, career bureaucrats who are hostile to Trump, the greatest threat was Flynn, not just because of his personal role, but because he knew where all the white hats were, who could clean house all the way across the board in all of the intelligence subcomponents and subparts of our federal law enforcement national security apparatus. As soon as he was taken out, they also effectively prevented those people from getting promoted. And many of those people chose not to seek promotions. And I know others that quickly sought exits out because they didn't want to be the next target. So that statement is a very apt and insightful statement. It is precisely really why I believe they targeted General Flynn. They wanted to prevent Trump from having his allies in key positions of power. And Trump partially enabled it by taking the bait and firing Flynn. If Trump doesn't fire Flynn, there's likely no Mueller investigation. There's likely no Ukraine impeachment. Neither one of those likely occurs. We're probably out of Syria sooner. We're probably out of Afghanistan already. All of those events don't happen because they take Flynn out.
And Andrew Starr says it's basically the mob. No honest people want to serve. Last question on the subject before we move on to the Michigan court order, the judgment. What role did Peter Strzok play in all of this?
Key. Peter Strzok was the agent who reinstigated the case when it should have been dead. When the line FBI agent had been looking at Flynn for several months related to the Russia investigation, everything else from late 2016 after Trump's election to early January 2017, they came back and said, shut it down. Strzok was the one who came in and said, no, we're not going to shut it down. He's the one who hid the original notes of the interview. He's the one who hid some of the other exculpatory information. He's the one that doctored the 302. He's the one who typed up a different 302 than actually occurred. The 302 being FBI terminology for here's a written recording of your conversation. And that's what it's supposed to be. It's supposed to be live notes, and then you type up the live notes and amplify the live notes on anything that's not captured in the live notes. Instead, what Strzok did was create his own. He wasn't at the interview, yet he wrote the 302. And then he creates a 302. He even writes into his lover, the Lisa Page, his mistress, who was the FBI assistant counsel and all this, a lawyer no less. He writes to me, I'm trying to make it sound like this other guy's voice. But, this is tough, trying to do this 302 in this other guy's voice that I don't know well. The stuff they said is, there's a great scene from the movie the show The Wire, where at one scene, one of the key great, Stringer Bell, one of the great, who was Idris Elba before he was famous. He goes up, there's a guy taking notes about their criminal conspiracy, and he goes up to him and he tears the notes out. He's like, you don't take notes about a criminal conspiracy. But Strzok did. Strzok kept notes, sent text, all the rest. He was one of the people involved in all this, along with Bill Priestap, who might have been a white hat. We don't know yet. But yes, Strzok was essential. Without Strzok, none of this happens.
Okay, interesting. And refresh my memory, a white hat means what again?
Oh, so it's a loose term for within national security or military structure. The white hats are sort of good, well-intended people. And the black hats are the dangerous, risky people. So it's just a language. Like sometimes in the States, people like Tom Mesereau, great criminal defense lawyer, he would always say you got to put a black hat on somebody other than your client. And he defended Michael Jackson, for example, got his acquittals famously. He's also defended a wide range of people over time. But he always said, find somebody that the government's putting up and put the black hat on them. So it's just a language to say who's good and who's bad, who's under a white hat, who's under a black hat.
Okay, very interesting. And now
probably back a little bit to the Westerns.
Okay. And now someone's Trick 4064 says, I blame Trump. Even me as a layperson knew that if Trump allowed Flynn to fall, the dominoes would go after. Trump has always wanted the leftist media to love him, and this will be his downfall. So it's an interesting thing. I follow people who who I wouldn't call them Trump lovers by any means, but everyone else would, and they're vehemently critical of Trump for a couple of decisions, one of which was, I never appreciated what they meant by it, but was stabbing Flynn in the back by firing him and abandoning him faced with all of this. And it makes, I sort of understand it now.
Well, like Mike Cernovich said at the time, that this was the end of any sort of effective Trump presidency. And his point was, Trump may still be politically successful, still may get reelected, but his ability to institute any of the policies within the national security structure that he got elected to do just won't happen. And that was very prescient. The second message that was sent, which I think Trump badly underappreciated, was not only did it purge all the white hats from the national security apparatus that could have protected and enforced Trump's policies in the National Security Administration, but it also sent a message that Trump will betray you even if you're one of your key allies. Nobody came to Trump's defense other than two people during 2015 and most of 2016 who had pre-existing political power. And that was Attorney General Sessions and a National Security Advisor, Flynn. And ultimately, now he had, I think, cause in the case of Sessions, but he ultimately shuttered Sessions aside. But he early on knifed Flynn in the back. In fact, one could argue that Sessions' ultimate recusal from the Russiagate investigation was because Sessions had seen what Trump had just done to Flynn. It was like, well, that's not going to happen to me. I'm just going to step back and not be in the middle of this. So it was a very poor, it was the worst decision Trump has made up until the issues surrounding the current shutdown. And at the time, there were some of us that said this is a disastrous decision. And a lot of Trump loyalists thought if you're second guessing Trump, it's inherently bad. And it's like, no, Trump's the kind of guy who needs feedback, especially when he's wrong, because he's not getting it from people inside the administration who either want to betray him or are just going to tell him what he wants to hear. And he needs to hear contrarian. He actually likes to. He'll get mad at you at the first, but from people who I know who know him, he actually wants people to second guess him. Nobody like if you're watching your kid run down the street and you see a big hole about 5 yards away, you don't say, geez, I really want to support my kid who really loves running, so I'm going to keep my mouth shut and let him fall through that hole. No, you're going to scream out, hey, there's a hole. Same with Trump. You need to warn him, and he may be irritated that he doesn't get to do what he wants to do right at that moment, but he'll be glad that he doesn't trip in that hole. And so the pushback was the correct pushback at the time. And now it even looks worse. I mean, there's some statements Trump made to try to defend himself back in December of 2017. They're just flat out embarrassing now, where he's like, oh, see, Flynn admitted he lied. That's why I had to fire him. It's like, no, you didn't. You got had. Admit you got had and grow up and move on. Mm-hmm. And it's a constant, continuous weakness of Trump that he has difficulty acknowledging when he's made mistakes. And that can be an advantage for him because the man can take hits from every which direction and be totally immune from them. But this was the place where it was not an advantage for him. And it was probably one of the biggest damages. It's probably why we're in Afghanistan right now. It's probably why he doesn't have the national security achievements he otherwise would. It's probably why we don't have a peace deal with North Korea. It's probably why both Ukraine Gate, impeachment, and Russiagate and Mueller all happened. Without it, probably none of that happens. It changed the whole course of his presidency in ways I don't know if he'll ever fully recover from.
Okay, phenomenally interesting. I'm going to bring up these super chats, and then we're going to switch topics to the Michigan thing. And they want to get to the point that Trump says he acts like a mobster. Wah, wah. Real Bambuga, thank you very much. Now, I noticed I'm going to fall behind because I noticed a lot of them blitz through. Here we got Andrew Starr. It's the tribalism on both sides. We have to come together as a people to demand better leaders. Robert, how do we stand up to this as citizens? Protest.
Well, I mean, I think at this point, a combination of civil disobedience, lawsuits, and public protest will likely be the most effective in getting people and getting the politicians to recognize the constitutional constraint on their power. Because I think that's it, really. But the people should never underestimate that the fifth pillar of power holds up the other four pillars of power. And that fifth pillar of power is the perception of the legitimacy of the other four pillars of power. The more they do not act in conformity with it, the more they contest it in their actions and in their conduct and in their legal remedies and in their public activities, political activities, the more they are able to restore balanced power to the proper place.
Okay, amazing. And now Jason L., nice to see you, Jason. What new documents from Judicial Watch seem to show Obama's White House had their hands in the Russia thing? If true, what's the ramifications of that? I mean, I suspect the short answer is none.
I don't anticipate any. I know there's a lot of talk. I'll believe Attorney General Barr when I actually see action. I do like the fact that Attorney General Barr signed people that released these key documents for General Flynn. But here's the reality. An honest and ethical attorney general who was actually going to do something about all this would have said, this is outrageous. I demand dismissal of all charges related to all Mueller case investigations because there was too much misconduct and malfeasance throughout. He's refused to do that in any case. Refused to do that even in General Flynn's case. So he keeps saying, hey, there's something. He keeps leaking stories through Durham and other people that, hey, those criminal. Remember last week there were supposed to be prosecutions, according to Fox News people. Fox News people said we've received key information and there's going to be indictments coming down this week. Never happened. So I know John Durham. I know some of these other people that are involved in these cases. I have no confidence in their willingness to take on anyone with real political power. I'm always idealistic at a certain level, but realistically, should there be more investigation into everything that happened related to the Obama administration? Absolutely, particularly as to this issue. People like Brennan, people like Clapper, people like Sally Yates should be disbarred and in prison. I do not think any of them will be at the end of the day, not because of their innocence, but because they're politically protected, and that's how our system really operates.
Okay, amazing. And now Real Bambuga says to Sir Barnes, how is it that Flynn never tried to graymail the prosecution?
Because his original defense team was actually working against him.
Okay, interesting. Mark Hargis 1111, I like the number. Viva Fry, off topic, I might be a little late on this. Is it possible to do a video on the Netflix documentary Making a Murderer? That's on the list. That is on the lower side of the list, just given the stuff that's coming up now in the news, especially in Canada. But thank you very much for the super chat. And there was one more that I know that I saw before we move on. No, there's one more. Let's here. And Star says, lack of self-reflection is brutal. There we got Jason Maynard who says, there seems to be no recourse against anti-constitutional laws and USA government agencies and incompetent government. Protest, sure, but what's it going to change? Who is elected and the evil they do? What can be done? That's a good segue into the next discussion. I know I missed a couple of super chats there, and I'm going to apologize in advance. Okay, I see one more. Good day, Barnes. Can state LEOs and government officials in places like Michigan, Oregon be charged under Title 18 USC, deprivation under color of law related? Okay, perfect segues into this. Thank you, both of you, Sekaki and Jason Maynard. Thank you very much. Let's do it. Let's talk about this. Now, so everybody knows what happened in Michigan. Do you know who this judge is? And not to name the judge, do you know who this judge of the, what is it called? The state court of claims?
Yeah, it's parallels the federal court of claims. So you often see like patent litigation and certain kinds of going to the United States Court of Claims. They created the equivalent of it in the state of Michigan. Though if the interpretation of the rules was what the Court of Claims judge said they were, that court seems to have no particular evident purpose except to prevent people from ever effectively filing suit. But it's basically claims against the government go to a specialized court in Michigan. It's one of the reasons I did not sue in that court. I don't trust those kinds of courts, not because they're like bad people or anything else. It's just institutionally, when you set up a court that's like that, they tend to favor the government and they tend not to rule in favor of individual plaintiffs.
Okay, so let's get so the state. It's called the Court of Claims. It's like, I don't want to say small claims, but it is a statutory court that exists, that was created to adjudicate on claims against the state of Michigan.
And usually the pretext is it's all this nonsense about sovereign immunity that still exists in the United States. The old doctrine of sovereign immunity was the king has been anointed by God, so he can do nothing wrong. So he is immune from suit in any form of court or remedy because he can do nothing wrong because he's divinely appointed. That's where sovereign immunity comes from. It's a doctrine that should have never been applied in American law. But our courts and our governments just couldn't help themselves. They decided, geez, it's so mean to have to sue a poor politician. Let's find excuses why the politician can't be sued. Well, we're going to say American common law somehow borrowed from British common law, the doctrine of sovereign immunity, and that a government is presumed to not be able to be sued unless there's unless the legislature passes a law that lets it happen. Now, the exception on the U.S. constitutional side is state governments and city governments and county governments are prohibited by the 14th Amendment from doing certain things and thus can be sued under federal law. But basically, there needs to be a law somewhere passed either by Congress or passed by the local legislature that allows a government to be sued in the first place. Michigan took it a step further and said, we'll only allow you to sue us if you go to our own handpicked court.
So, and just so everybody can appreciate the absurdity of this, the government has to pass a law authorizing or granting the right to the citizens to sue the government for wrongdoings.
Yeah. Exactly. Okay. And my view always was like, people are like, oh, we're worried this will go excessive. Every case should just be a jury case. Let the community to decide whether what the government did was wrong, even if the government did it on behalf of the community, and the community is probably better equipped to handle that than anybody in a jury system. But they don't like that to happen because that tends to hold rogue politicians who are in the pockets of the powerful responsible in ways they don't want to be.
Okay, so the state of claim is created under Michigan law, the court of claims, sorry, to adjudicate on claims against the state. Mm-hmm. Why on earth, if I'm the plaintiffs in this case, am I filing the lawsuit in the court of claims and not with the federal court?
The only reason to do that would be if you believe that that state court will be a more favorable venue to you than the federal court. And you may be looking at it from three different angles. One is you may say that we may get a trial court judge that's better. The second is you may say, well, the way the appeal rights work, we may get a better appellate branch. So you look at, in Michigan, you're looking at, I believe, in Michigan will be the Sixth Circuit Court of Appeals. You may look at it and say, oh, we don't want to deal with the Sixth Circuit Court of Appeals. We'd rather deal with a Michigan Court of Appeals or a Michigan Supreme Court. Or maybe we like our Michigan Supreme Court more than our United States Supreme Court on these set of issues. So it's simply, you're trying to pick your decision maker. That is usually if you're making a tactical decision. My hunch is there's a lot of people that don't do a lot of these civil rights cases in this context. And so they just tend to sue wherever they're used to suing. So I've run into this in talking to local lawyers about bringing all these cases all across the country that I'm looking at. And you run into a wide range of people who assume things because they're not familiar with civil rights cases, how they work, where they're stronger, where they're weaker, where they're better. Here's my simple view to people all the time. Always sue in federal court, because if you sue in state court and the local and the defendant knows the state court is a better court for them, they won't remove it to federal court. But if they look at it and say, oh, you know what, the federal court would be a lot better for us, they'll immediately remand it to federal court. So when you sue in state court, you are shifting tactically the power over your court to the state defendant, who can only make a decision to screw you around. Whereas if you file in federal court, they cannot withdraw it to state court. So I always file in federal court, because the only circumstance in which state court is better for you won't be better for you because the other side will remove it to federal court.
And I think I touched on this in one of the Jussie Smollett vlogs, but federal court judges are appointed and not elected?
Yes, that's correct. They're appointed for life, tenure for life. They may have been appointed by a different political person, 10 years ago, 20 years ago, 30 years ago, 40 years ago. So they tend to be less susceptible to local political pressure and temporary political pressure. And they also have law clerks, usually 4 law clerks on average, that are some of the top law students in the country. Now, you run into some ideological bias there sometimes that can be problematic depending on the nature of the case, but you're talking about people that are very sharp. On the state court system, they generally don't necessarily have the same professional pedigree, and they usually have no clerks helping them out. So on intellectual issues, you're putting a lot of pressure on a state court judge to figure out a whole bunch of complex issues they may have never dealt with before without the resources or to be able to make it an easy decision. And most state court judges are elected, so that they will rarely buck the local politics, the power politics.
That alone is something that I just put together now, is that this judge, because a lot of people in the comment section were saying this judge is up for re-election in whenever, remember that. And now I'm realizing, like, if this judge thinks that his constituents want him to reinforce this stay-at-home order, he is rendering a judgment that is going to be voted upon by the people who are going to either re-elect or overturn him. And that is,
and by the people that can either help him raise money or help his opponent raise money, that institutional people. Knows if he rules against the governor and the Democratic political establishment in town, he's going to have a permanent political adversary. Whereas if he rules in their favor, the only people that are going to oppose him are some local people that are trying to protest the issue, but not people that have the same degree of political juice or institutional influence that the institutional players he would have to offend and upset by ruling in favor of the plaintiffs.
And now the thing you mentioned, I'm just looking for the portion of the judgment that you mentioned now, which here we go. You mentioning the clerks now, and for God's sake, I love the fact that this starts making sense. And when the pieces come together in my head, it gives me a deep sense of satisfaction. In the judgment, we'll get to it. Page 10, he says, binding authority from the United States Supreme Court and the Michigan Supreme Court compels this court to conclude that plaintiffs do not have substantial likelihood of success on the merits. This is talking about the preliminary injunction. And I read this, and I'm like, holy kids listening, holy shit. Where's the citation? What is the compelling case law that this judge is relying on to come to this not just radical conclusion, but fundamental conclusion that they have no chance, even when they have no likelihood of success to justify granting the preliminary. He says it. Where's the case law? Because I looked, there was none. And I thought it was a peculiar thing to cite the binding Supreme Court and Michigan Court without referencing it. And you mentioned this down, it all starts coming together. It's crazy. Okay, let me get this. This one's going to drive me crazy if I don't get up. Bobcat, off topic. Could you cover the Rob Ulbricht case? It's off topic. I might be able to do it one day. Too many things, and I know I missed a couple of other ones here, but it seems like the deep state needs a crushing blow. Someone who's big, someone big, not a scapegoat, destroyed. Can this still happen within the course? Is it too late?
Definitely. If Barr wants to prove he's legit, he needs to go after someone like James Comey or Andrew McCabe. Until he does, everybody's just going to shrug their shoulders and say it was mostly rhetoric to keep Trump happy and keep him quiet while they just swept everything under the rug.
Okay, good. Sorry about that. Now I'll feel better. I missed a couple of super chats, but I apologize. I can only do my best. This Michigan judge, basically for the Court of Claims, says one thing I don't understand. Someone's got to clarify this in my own brain. A law can be constitutional or it can be unconstitutional. If it's unconstitutional, it can be justified or unjustified, right? So a lot of people are saying, well, the judge said it's constitutional. And I think, no, the judge said it's unconstitutional, but justified within the limits of the regulation of civil rights in the public interest. So it's constitutional or unconstitutional if, good, bad. If it's bad, is it justified unconstitutional or is it unjustified unconstitutional? Is that the right way of viewing this?
It's a correct interpretation of what he did, or a valid interpretation of what he did. It's not consistent with the law. Now, there's two different issues here. One is that our early jurisprudence by our Supreme Court in issues like this originally did not require what's called strict scrutiny. In fact, that's a relatively modern creation, this legal interpretation called strict scrutiny. And strict scrutiny says when you have a core constitutional right that is being infringed, the government that law or that action has to meet the strictest possible scrutiny, which as applied means there has to be a compelling public interest, and the means used has to be narrowly tailored to that compelling public interest. The counterpoint, the argument all the city, county, and state governments are making is to say, oh, you know what? Strict scrutiny doesn't apply in cases of virus or public health. There's no logic behind that. Even in the Korematsu decision where we had war, they said strict scrutiny applied. What they're using is the loose rhetoric of the eugenics era Supreme Court, which people forget our U.S. Supreme Court embraced and endorsed eugenics effectively between 1904 and 1930. They did the first decision. They said they had two decisions where one part of a neighborhood in New Orleans was carved off, and they said, was that okay? And they said that was okay in the case of a quarantine. But they were not evaluating strict scrutiny at all. They were saying, does the government ever have the police power to ever do that? Not, does the government have a constitutional obligation to use less intrusive and invasive means where such alternatives are present? That analysis is never done in any of those cases. Because people originally challenged these actions because they were saying there's no police power for the government to do this, period. And remember, this is a time period in which the court is saying, oh yeah, governments can't even regulate child labor laws. So that was the theory that these people were advancing. Like, well, if you can't regulate child labor laws, what allows you to regulate whether I'm forced to take a vaccine? What allows you to regulate whether you can shut down my whole neighborhood for a week? And it was in that context, that framework, that the Supreme Court said, yes, it's okay. It's okay to force a vaccine in a smallpox outbreak case in Boston. That's the Jacobson case that judge is citing. By the way, the way he cited it is a giveaway that he's cutting and pasting from the government's brief because he gets it wrong and there's certain reference points that are off and so forth. But that's what happens with state court judges. The other component, the other decisions along those lines led to them saying forced sterilizations are okay. This was a bad era in Supreme Court history in the U.S. The United States basically was in a eugenics epidemic that led to ultimately Nazi Germany in the 1940s and 30s adopting the same ideology. And some of those decisions should not be cited. What I can't, like in all of my cases, my argument's going to be simple. Korematsu says strict scrutiny applies, so it applies, period. I'm not questioning whether the government has a police power to ever issue a quarantine or ever force a vaccine. I'm saying that when they infringe on a constitutional right in the process of doing so, they can only do so if they meet strict scrutiny. And that we should not allow the trilogy of infamy from the Jacobson to Korematsu decisions of 1904 to 1942 to become the continuous jurisprudence of the U.S. federal judicial system. Because almost every judge alive today recognizes that Korematsu was a horrific decision. But it was a horrific decision rooted in that earlier bad logic that said, hey, you can do what you want if it's the police power. But he's deliberately playing games intellectually with what he means. And that's why you're seeing circuitous and circular logic applied in his decision. Because he can't say honestly and straightforwardly, hey, you know what? All strict scrutiny doesn't apply. And I'm just going to say Jacobson overturned strict scrutiny because that will look bad on appeal.
Well, so and that's the other thing is he basically says, I forget the way I phrased it in the video, but he basically says it's not up for us to second guess the regulations that the government imposes. We just have to determine whether or not it's constitutional or unconstitutional. And if it's unconstitutional, whether or not it's justified in light of the risk. And if we say it's justified in light of the risk, he said it almost verbatim. We don't assess the narrow drafting of the legislation. And that's, I mean, I'm paraphrasing and hopefully not mischaracterizing too much. That's where I said, that's idiotic. What you do is you say, if it's not as narrowly drafted as necessary to achieve the objective, strike it down, implement it for 2 weeks while they redraft, and send them back to wherever their legislature is to redraft, and then redraft it in a scope that might be constitutional, but it doesn't have to be, mayhem in the meantime. We'll keep it in a force, give you 2 weeks to do it. That's what we do in Canada when it's, when this happens. And no, this was like, we don't second guess the legislation. If it's justified, it's their prerogative, not ours. We're not there to guess, play Monday morning quarterback. That's for athletes or sports fans. And so basically we're here to do nothing. We're here to do nothing because we've come to the conclusion it's unconstitutional, but we're not second guessing the scope because that's for the legislature to do.
Exactly. One thing real quick. I need to get my power stick to plug in. I was about to run out. But yes.
Someone says, Viva, we need you down here in the South. Can we get you into the States and sponsor your citizenship? Not yet, but we'll talk.
Yeah, exactly. I don't know whether Canada or the U.S. is the best place to be right now. There's good arguments. I was talking with a friend of mine who's lived in Colombia right now. I was like, maybe that wasn't the worst idea at the time. I wouldn't have thought of Medellin as the best place to go. But hey, it's a new wave. It's a new day. But yes, what you're pointing out is what he's talking about is narrowly tailored, because he's admitting these laws are not narrowly tailored. And if they're not narrowly tailored under strict scrutiny, they have to be struck down because they violate constitutional rights. And he doesn't want to mention that standard. He's just going to say, I'm not going to apply this, and I'm going to pretend that we're back in 1904 and that our only legal analysis is, does the government ever have the power to do this? Not what happens when the government infringes on a constitutional right in the process of doing so.
The strict scrutiny, I mean, that's what I mean, it was not addressed properly in the decision. I didn't fully appreciate it, and now I do. And for everyone who's watching, if a law is unconstitutional, it has to be as narrowly drafted as possible to achieve the goals. Yep. Failing which, strike it down, unconstitutional, go back and redraft. That's what you guys get paid for.
Exactly. Because otherwise the Constitution doesn't mean anything. Because if you can simply, you no longer have rights, you have permission slips if that order is upheld.
It's actually what Joshua Cornelius literally just wrote is the U.S. Constitution is no longer the law of the land. It's now considered more to be a suggestion to be considered when everything is peachy. It's crazy. I mean, it is mind-blowing, and it's amazing to view it from Canada, but it's also amazing to view it from Canada, seeing what's happening in Canada. Everybody, we've made the news because of what our prime minister has just unilaterally decreed.
Yes.
So how does it? So in law, I mean, I don't think it's a partisan biased thing. This decision is crap. I mean, I would argue this decision. Not to be disrespectful, it's a bad decision.
Yeah.
Does it get appealed?
I'm sure it does. And then the question is whether Michigan, the only thing I'm not sure of in Michigan is whether it goes straight to the Michigan Supreme Court or there's a Michigan Court of Appeals that deals with it. That part is unclear to me because my instinct, as soon as I researched it, I was like, no way I'm going to Michigan State Court. Like, I'm going to federal court. It's like I may run into tough luck there too. But, I like my odds a lot better for the reasons articulated. Now, in that context, the Sixth Circuit Court of Appeals has now twice struck down some of these shutdown orders. So I like our chances in the Sixth Circuit Court of Appeals, and we'll see how that goes.
So, and actually, always enjoy watching the two of you live stream. Thank you very much, Bex Fire. Let me just see this. With all the malfeasance and violation of rights, how can you still believe in the Constitution? The Constitution is a joke. Either it allows all of this or it cannot prevent it. Politics is a dirty business. And without getting fixated, and this is actually another good segue, without getting fixated on the doom and gloom of some bad decisions that we see from the Court of Claims, there have been good decisions throughout the U.S. striking down these draconian stay-at-home measures.
There's been a real split. So what I told people up front was two things. One, I was not going to rush in to do temporary restraining orders because my view was if you put a lot of pressure on a court to make a quick decision, they're going to rule in favor of their political allies in government, not the little guy challenging them. And then they lock into a mindset of justifying that throughout the rest of the case that makes it tough for them to reverse it. The second part of it was that our biggest hurdle would not be the law, that the law was pretty clear that any narrowly tailored and that one, strict scrutiny should apply, and two, that if you did, nobody could justify 90% of these restrictions. And so the concern was, but what I told people was the problem is we have a political problem, not a legal problem. That through the entire history of the American legal system, most times when there's been a crisis, the courts have turned a blind eye to ordinary people, no matter what the nature of that crisis is. It's very rare that the courts have stepped in and stepped up to the equation, especially the more emergency the crisis feels. So that's how Korematsu happens during time of war. That's how during public health crises, you almost see the courts never second guess a quarantine order. Now, there's never been a quarantine order like this one. But, I mean, about 10 years ago in Arizona, they said this guy had communicable TB, put him under a strict quarantine order, jailed him effectively. Turned out they were completely wrong the whole time. They didn't figure that out until a year later. But they're just so, the fear reaction, the panic reaction, in the judges who are like, hold on a second, you want me, maybe now I'm going to get blamed if a bunch of people die because I set aside the order. So the fear is so disproportionate to one side that in these kind of political cases, that's going to be the big hurdle to overcome. And that's why you're seeing such a split. You're seeing decisions in California that were just inane. You're seeing federal judges issue decisions that don't make any sense. I did love the Orange County judge. That was a classic. He was like, I'm just going to kick this down the road a couple of weeks. I'm not going to order a temporary restraining order. I'm not going to say it was a bad idea to seek one. I'm just going to let this go a couple of weeks. That's, I respect the judge who understands the conundrum they're in and just decides to, Solomon split the baby in half. But that's what you're seeing. And you're seeing a lot of federal judges. The Fifth Circuit issued one ruling. They said, hey, you can do what you want in the shutdown, citing Jacobson amongst others. Sixth Circuit said just the opposite. District Court Judge Yackel, I love him. He's a great old school judge in the Western District of Texas, in Austin, Texas. He was the one to say, hey, there ain't no emergency exception to the Bill of Rights. But he got overturned. So you're seeing a lot of, ultimately, the U.S. Supreme Court will take one of these cases. A lot of state Supreme Courts will take some of these cases. And when they take it and how they take it will be critical. That's why I've been very selective with which cases we bring against which politicians. But it's critical but it's terrifying because people are right. Our Constitution is just a politician's permission slip unless these precedents get reversed.
No, and somebody was saying the Bill of Rights or the Constitution was not drafted in a time when plagues were unknown. And this was not all. Some people, I learn almost as much from the comment section as I do from my own research. Someone said, if they wanted to make this subject to communicable diseases, they had all the fodder or all the justification they needed at the time. They said your constitutional rights were not subject to a virus. And if they're going to do this, they'd better well have the best damn excuse possible and draft it properly, not just stay at home. And what was the thing I was thinking about, which was, I'm gonna forget my thought. Whatever. They're basically like a sledgehammer to a fly, where it's like stay at home and it's all justified because of the risk. That was it. The evidence of the risk, this judge in particular, talking about numbers, I don't know what scientific evidence was adduced at the hearing to justify the validity of these unconstitutional orders, even as necessary as they may be. What evidence was presented?
And exactly on that front, when they have forced them to admit evidence in these cases, so the cases coming out of Kentucky and Tennessee that went up to the Sixth Circuit, the politicians that issued these orders could not come up with any evidence to justify what they did. They could not show any relationship between their order and it limiting the scope of the virus. They could not show any relationship between the order and it limiting the number of deaths. They could not show any relationship between the order and how many deaths it might cause. They had no idea. They just said, hey, this is a great power grab. The media says it's great. We got a few experts in white lab coats that say it's great. We'll say it's great even though we haven't done any research ourselves and we can't produce any admissible evidence in these hearings to back these up. The government so far, when they're put to their test, and my guess in Michigan is they likely weren't put to their test because he didn't cite any evidence. I guarantee if there was actual evidence, we would have had pages and pages of it. We would have had, according to this great resume of this epidemiologist,
No, it was one paragraph, which just, in 1 month ago we had X, now we have Y. And
yep.
Okay, so it says, Sarusa says, taking your kids to a closed park in 2020 is now equal to dumping tea in Boston Harbor in 1773. Yeah. I pet somebody's dog and I let someone pet my dog. I felt like I was committing an act of like egregious outrage. Joel Rowley says, if you are a court of claims, why not make this decision by the time appeals are heard? The Schmandemic will be over and deemed moot, strengthening pull power. So interesting question, actually, and it's going to remind me of the other question I had. These executive orders might lapse by the time any appeals comes around. Does the appeal become academic or do they pursue it as a matter of law?
They should. The jurisprudential doctrine of mootness is not a jurisdictional requirement. So all that's required for jurisdiction is that there have ever been an actual dispute. So the fact that the dispute is now what they will say is moot does not by itself remove the courts from having power over the dispute. It becomes a discretionary matter as to whether they can dismiss it on grounds of mootness. But there's one time where they're not supposed to grant dismissals on grounds of mootness, and that's whenever it's, quote, capable of repetition yet evading review. In other words, is this something that can happen again, and will it be something that will not facilitate quick, easy appellate review? That's exactly what these cases are. So my belief is that these cases are not moot, and that the appeals courts and ultimately Supreme Courts of the various states in the United States ultimately can and will hear some of them.
Okay, amazing. And I took a screenshot just so I can use this as the thumbnail or to resell this stream tomorrow. Robert Barnes for Attorney General, am I right? We discussed this in previous vlogs, but Robert doesn't think his chances are high for that.
Yeah, no. I would take out a big life insurance policy as soon as I was anybody recommended it. I do not think that would go well with certain people in positions of power.
Collector says the Constitution is not a joke. The politicians people vote in are a joke.
More than one. Right now, that's for sure. We're seeing a disgraceful groupthink, herd mentality, herd mindset that has been very dangerous to our liberties and freedoms. Especially what's insane is the more we get good information, the more they go crazier. So like the governor of Oregon is facing almost no problem. The governor of Oregon says, hey, we're extending this until July. It's like, why? I mean,
because it's been so effective. I mean, it keeps away the elephants. I mean,
exactly.
Ken Davis says, which I saw at the start of this. I'm glad AG Barr seems to have his head on straight.
I think he has good intentions. How much action he'll take is we'll find out.
Is this a 10th Amendment question?
Only kind of.
What's the 10th Amendment for any?
That all governments, that all powers not explicitly and expressly given to the federal government are reserved either to the states or the people respectively. So mostly what the 10th Amendment is right is that if you had a right at the time of the Constitution, then that right wasn't taken away, even if that right wasn't enumerated in the Bill of Rights or within the rest of the Constitution. So that's all that really means. So it might have relevance in the travel context. So there was a right to travel, a right to interstate travel. Now, arguably, that's there in the Privileges and Immunities Clause of the Constitution, also implicitly there within the Fourth Amendment to the Constitution that prohibits arrest, which is about restriction of movement without probable cause of a crime or clear and convincing evidence of mental health or physical health risk. So you can make those arguments in that context, but the 10th Amendment will not be the primary constitutional issue. It will be the other amendments, 1st, 2nd, 4th, 5th. Those will be the big ones, and the 14th.
Okay, amazing. And we got Joshua Cornelius says the most horrifying aspect of these tyrants running rampant is that many of them will suffer no consequences of the ballot box. The automaton nature of so many citizens is what gives tyrants their power.
It's a good time to watch V for Vendetta.
I think I'm wondering if my oldest daughter is not too young still for that, but
that's true.
I think we might have to do it. And we got Zaria 3148 super sticker. Thank you very much. Okay, so now I think we can unequivocally agree that the decision is garbage. Other states and other jurisdictions have been rendering decisions in the opposite direction. There's going to be a back and forth because, like you say, no court of claims judge in Michigan is going to want to be responsible for granting a decision that results in a spike the day after the decision. And everyone in the media says, I forget what the judge's name is. It doesn't really matter, but look what this judge brought on you. Mm-hmm. I mean, that's the thing is, ordinarily, you falsely convict or you graciously release a criminal. It's a one-off. It affects them and maybe immediate circles, victims, and family, but not society as a whole. Where if this judge says strike down the order and then something happens, and this is what people were don't necessarily appreciate in the comment section is it's not that the judge had to say it's what's the word mayhem as of tomorrow. They could say I'll keep it in effect for 2 weeks. Just go draft something properly and take it from there. Like it didn't have to be all or nothing.
A smart judge could have called him in chambers and said, here's what I think. I think this is problematic. This is not. Maybe if you guys go back and redraw the executive order along these lines, I'll say no problem and say the rest of the dispute is moot. And that's what would have been the smart, savvy thing for them to do. But very few judges feel that degree of confidence that they can do that with a governor or mayor or politician. And so I think that's a large part of it. I compare this a lot to bail cases. So bail cases have this disproportionate political risk. On paper, the law says someone's supposed to get bail unless there's clear and convincing evidence that they are a risk to the community of a serious crime, or there is more than a preponderance of the evidence that no set of restrictions will make sure they show up at trial. There's almost nobody who should not be released on bail because there's always some set of restrictions that you could impose on someone to preclude a bad event from happening in all likelihood and make sure that they show up at trial. You can revoke their passport. You can put them on electronic monitoring and so on and so. You can require a financial contribution so large they'll never want to give that up, etc. Yet that's not how judges look at bail. Judges look at bail and say, if I release this guy, if there's a 1 in 20 chance that they go out and do something bad, they're going to hang me for it. So even though I'm going in and I'm supposed to get bail for my client, if he's just 51% in the right, the reality is unless I persuade the judge he's 99% not a risk, I'm not going to persuade him of giving him bail, despite the 8th Amendment saying he has to. And the same context is here. They see the risk is weighted so heavily in one direction. That's why I've been drafting the suits, looking at the right time to file, gathering evidence in support of them, because my argument's going to be that this shutdown is killing people right now. This shutdown is killing it's locking elderly people up in nursing homes in ways that is killing them at a record rate. It's locking them up into subway cars in ways that likely led to the key epicenter of the epidemic in New York City, likely maybe in Italy as well, likely maybe in Wuhan as well. And that the medical health collapse of medical health capacity and the collapse of food supplies and the economy is threatening not only millions of Americans who may die because they did not receive the elective treatment that they needed, including cancer treatment, heart treatment, et cetera, but they're now estimating 130 million people around the world, including mostly children, are at risk of starvation and dying from starvation in this year if the economy does not get restarted and most civil society gets restarted in the West because of how dependent those children are on certain economic and human food storage supply needs being met. Because then that shifts the burden on the judge to say, no matter what you do here, there may be risk. So, I'll hang it on your the record around your neck that you helped kill hundreds of millions of kids unless you rethink this. So if you change that so the judge is like, okay, people will say this about me if I go this way. They'll say the same thing if I go the other way. All I'm asking the judge then to do is just rule on the law. Ignore the politics, rule on the law. The law says this was not narrowly tailored, must be struck down.
Amazing. I mean, it's an amazing way of reframing it. I try to have this argument or discussion with people, and it's very frustrating. They talk about the numbers without appreciating elective surgery, not showing up for elective surgery. It's not showing up for a ganglion cyst. It's cancer patients who are too scared to go to hospitals to get their therapy. It's people who are not going to the hospital when they think they're having a heart attack, and the old person homes. And I mean, incidentally, in
people
Canada,
that have appendicitis that aren't going in until it's too bad. I mean, I got these direct responses, and it was nurses who started blowing the whistle on this from the get-go. They were saying what's happening is going to kill people, and it's going to kill people because of lack of medical care being accessible to them, lack of cancer care, lack of heart treatment, lack of other critical. Almost all of our preventative medicine has disappeared overnight. And the point of preventative medicine is not only saving on cost, it's saving on lives. And we just eradicated it overnight. And so it shows the degree to which what we've done is going to cause far more harm. This isn't about getting a haircut, though I would like to get one of those sometime soon. It isn't just about the stock market. The Fed and all the central banks can take care of that. It's not just about the mom and pop business that's going to lose their life dream. It's about the person who's not going to get medical care who needs it. It's the person who's not going to get food who needs it. It's the person who's not going to get shelter who needs it all around the world, including the most vulnerable amongst us, because a lot of politicians want to pretend that we've reinstated royalty in America.
Amazing. Okay, I'm gonna get through these super chats, and then we're probably gonna wind it down, I guess. For Robert, what do you make of Lysander Spoon's arguments regarding the inapplicability of the Constitution owing to lack of consent?
The great Lysander Spooner.
You have to explain that because I don't know what it means.
1840s. My favorite article of Lysander Spooner is The Unconstitutionality of Slavery, how slavery was never constitutional. Also shows how politically motivated our courts can be, that was never cleanly ruled on from the 1600s all the way through the Civil War, when it could have been. That may have completely averted the Civil War. Just say, by the way, slavery is unconstitutional, can't happen. Would have totally changed things. And Lysander Spooner was probably right. He co-wrote that with the great Frederick Douglass, who self-taught himself how to read by reading Cicero's On Oratory, which I also recommend people read. I do not happen to have familiarity with that particular piece of Lysander Spooner. He did become one of the great anarchists of the late 19th century, and the reason is interesting. Lysander Spooner was a deep believer in the law, a deep believer in the Constitution. When he saw it constantly ignored for about 50 years, particularly in the context of slavery and race, but also other issues in the United States, he lost all confidence and faith in the American legal system. And because of that, that's what led him to become an anarchist. He became an anarchist because he was a disappointed dreamer, not because he was a radical, chaos-oriented individual. But a very brilliant mind, but I can't speak to that precise article because I haven't read it.
Okay, amazing. And incidentally, we got Uncivil Law, who became a new member, which is always fun to see. We got Joel Rowley, who says, what about the 9th Amendment argument, quarantine's not addressed?
Namely, that the point is that if the founders wanted to include any form of either emergency exception to the rest of the Bill of Rights or simply give a constitutional empowerment of quarantine, they would have done so. So that because they were intimately familiar with viruses and plagues, and yet they never even reference it in the entire organizing piece of the document. And my view is real simple as to why, is because they didn't want any exception to the Constitution included in it. And they saw the emergency exception is very dangerous. It's what killed the Weimar Republic. One of the great constitutions in history was the Weimar Republics, but it had an emergency exception that ended up completely negating it, leading ultimately as the political and legal pretext for the Nazis to seize power without getting Democratic majority support. In the same context that I think our founders anticipated that in advance, and that's why there's nothing there. And that also correlates to the 10th Amendment argument the person was making earlier. Any power not enumerated in the Constitution to government was a power they don't have. Now, what happened in those early Supreme Court cases is they said, well, the police power includes a quarantine power. The police power includes a vaccination power. The police power includes a sterilization power. Well, okay, I'll concede part of that. But that does not mean, even though I'm more of an old school guy, it's like if you really want that power, pass it through the Constitution legal means. Amend the Constitution for it, pass it appropriately. But putting that aside, at a minimum, it doesn't meet the constitutional strict scrutiny standards that it's supposed to apply now when a constitutional right's being infringed.
Okay, amazing. Joshua Cornelius says, would a good course of action be to disobey Whitner's orders, let them enforce it with arrest, then call Barnes to file a civil rights lawsuit?
I never encourage people to break the law. Though I will say Martin Luther King is a hero of mine, so take it as you wish. In that context, my view is that you can challenge these laws without having to break them. There's a lot of case law on that. So as long as you have a reasonable risk that the law is going to be enforced against you, you can bring suit without having to go to jail to confirm your civil rights.
And now that actually reminds me of a comment that I saw frequently on the video on the Michigan stay-at-home order, which said the undoing of the plaintiffs was that they filed a due process claim and not a civil rights violation claim. Yeah,
that was it's a misnomer. So any due process claim is a civil rights claim. It's just what statutes it's brought under. So under Title 42, Section 1983 of the United States Code, which annotates all the public laws, puts them together. That is a civil rights claim, which is most commonly brought against the states as a due process claim, but incorporating all the other rights. So like the First Amendment on paper only applies to the federal government. Same with the Second, Third, Fourth, Fifth, Sixth, etc. The 14th Amendment applies most of the rest of the Constitution to the states through its due process clause. And so technically a free speech claim, when you bring it against the state, is a due process claim. It's saying as part of my due process rights, I have free speech rights protected under the First Amendment enforced against the states through the 14th Amendment's due process clause. So that interpretation is a common misunderstanding. One other component the judge got wrong, the judge's interpretation that it should not have been removed to federal court makes no sense at all.
Oh, God. I'm sorry. Thank you for bringing it up. He says they didn't sue the state, but they sued individuals. It doesn't matter that it was in their official capacity as governor of the state. It's not a lawsuit against the state. That's when I got the impression the judge wanted to keep jurisdiction so he could dismiss the suit.
He wanted some political juice, because here's the story he didn't tell. By definition, you can't sue the state in federal. If he was right, you could literally never sue for civil rights effectively, because under his interpretation, if you're suing individuals in the federal system, that's not something that is a true federal civil rights suit, kind of the way he interpreted it within the meaning of the state statute. The thing is, you can't sue the state in federal court. I can't sue the state of Michigan. They're immune. I can sue an individual, however. So the only way you can bring federal civil rights suits, because they interpret the 11th Amendment to give immunity to states. So the net effective is the only way you can bring a federal civil rights suit is against an individual. So when I saw him say that, I was like, that doesn't make any sense at all, because all federal civil rights suits by definition are not against the state in the name of the state. They're all against someone in their official capacity as an individual, because that's considered an exception to the 11th Amendment for purposes of federal civil rights laws.
That's okay. That's amazing. And when I saw that, I mean, for anybody who hasn't seen the video, I suspect everybody has seen it, but he said the defendants moved to transfer the case to federal jurisdiction under the provision of Michigan law, which says you can't sue the state in the court of claims. And
in fact, that whole exception was that if it's a federal civil rights claim, it's supposed to go to federal court, because they didn't want the complex issues of jurisdictional analysis, and it was because civil rights lawyers included that provision in the law. So it's commonly understood within a good number of civil rights lawyers in Michigan that I know that you can't bring a federal civil rights claim in the court of claims for that very reason. And so they tried to anyway, which told me that they were people that maybe weren't that familiar with federal civil rights laws. They were rooted in something else. But when the judge was like, oh, no, this exception could possibly never apply to this set of circumstances, when that's the only possible set of circumstances that it could be intended to apply to. It was not a good faith, in my view, interpretation of the law, or it showed a degree of incompetence that's a little frightening.
No, and so the judge says, because they're not suing the state, they're suing Whitmer personally in her capacity as governor, so therefore I have jurisdiction. And then he said also, because it might call on us to impose state law, we have jurisdiction, when maybe I'm wrong, but from what I understand, even the federal courts can still apply state law in a lawsuit. Tell me if I'm wrong.
Yeah, they have supplemental jurisdiction over those.
Supplemental jurisdiction is
and clearly that's what the purpose of that law. The purpose of that law was, hey, if you have a state law claim, bring it in the court of claims. If you have a federal civil rights claim, bring it in federal court. That's clearly what that law is intended to mean. The judge's interpretation of it makes no sense.
Okay, amazing. All Metal Mike says, this brought a magnifying glass on politicians. We are seeing their true nature. Hopefully the sunlight of truth will let them not be reelected. We'll see. We'll see. I mean, it's we got, well, I'm going to pronounce it, Deeth says, let's not forget the shutdown's effects on mental health.
Oh, yeah.
No question. I happen to have close friends who, the parent of one of my kids who's a psychiatrist, my old high school friend who's a psychologist, cognitive behavioral therapist. They're seeing it. I mean, I know that they're seeing it. It's just, we'll see the impact when the numbers get out and when the effects get out, but there's no question about it.
Yeah, there's studies and surveys that estimate anywhere from an average of 2 years loss of life expectancy, mostly due to mental health related issues as this shutdown goes on. Yeah, and Joshua Creeley says, sorry for his last question. Don't worry about it, Joshua. We all know you were joking. Okay, and I think I saw something. We saw a new member here, and then I think we should wind it up. Robert, what time is it where you are? 9:45. Okay, so we're on the same time zone. I hear a kid running around upstairs, which is always surprising. Nick Schaefer became a YouTube member. Nick Schaefer, welcome to the channel. And there was one other super chat, and then we're going to start. Hopefully, I can get some comments that are not super chats. We got Isaac McKay says, for Robert, why doesn't the Second Amendment coupled with the Supremacy Clause render all state-level gun laws null and void? Aren't they all infringements? Essentially, it's that some reasonable laws are still relied, so it are still permitted. So under the Second Amendment, you have a right of self-defense. That right of self-defense includes the right to purchase arms for that self-defense, but they can regulate it under the same strict scrutiny analysis. Okay, fantastic. And now I'm just bringing up some comments here. The unemployed have a 63% higher mortality rate than the unemployed. The employed. There were some stats. I mean, Robert, you know the stats on correlation between mortality and unemployment. Yeah, it's usually for each 10% increase in unemployment, there's at least a 1% increase in the mortality rate. So the example I always use is the Depression. So in the Depression, the half of all people who got sick never saw a doctor at all, and a third of people who got severely sick never saw a doctor at all. It's when our healthcare system, the economy is just the way we exchange our means of feeding each other, sheltering each other, and caring for each other. When we take that away, there major problems occur. There's a reason why none of us are rushing to go to third world hospitals, but we're going to create third world hospitals in America. In fact, we have overnight. Okay. On that note, I mean, let's wind this up. I guess we didn't forget anything, Robert. Right? I think that was good, expansive, full, good, quick, and on point. If anyone's looking for the time markers, Robert, a website where people can reach you. I want to get it in there, but remind people where they can reach you. I'm still live on Twitter. You can find me at Barnes_law. You can go to the website BarnesLawLLP.com. People can I know there's a lot of people that are asking about bringing cases. They can use the contact form on there to reach us, and we're using that to look at and filter through cases and see how many we can take, see which ones we can take. And then also there's a legal organization that I helped found that's supporting these suits, which they can find at Free America Law Center, which is www.freeamericalawcenter.com. Free America Law Center. Is it center R-E or E-R? So C-E-N-T-E-R. Okay. It turns out to be particularly well named these days. It wasn't part of the process for this purpose, but wow, is it applicable. Robert, I say you're doing God's work, and it's enlightening to a point where I can't possibly express it, because you fit these puzzle pieces together in my head, and I suspect in everyone else's head who's listening to it. It's amazing, and I can't thank you enough for taking the time to do this. I want everyone to appreciate. I was looking back at our streams, Robert. We've had marathon streams and multiple, and you've given me time and you've given me knowledge, which is invaluable. So I thank you sincerely for everything you've done. Fantastic. Thanks, man. Okay, I'm going to end the broadcast. You and I will talk for 2 more seconds. Everybody, stay safe, stay sane, exercise, sunlight, and I'm going to put my thumb over the lens. Peace out, people.